I've been given the task of reducing the sociability here and messing up the end of your lunch here. We've got some more things to talk about, and so we should get started. My name's David Savage. I cover the Supreme Court for the LA Times. I'm sort of a substitute here to Tommy Goldstein and some others were planning to be here, and Tommy is apparently on his way out to Los Angeles today. So I'm glad to be here, and we're going to talk about, we've got two speakers to talk about sort of the nature of regulations, not just the question of agency regulations, but the sort of eminent economist, Allan Meltzer, wants to talk about the sort of nature of regulation, and I've read his paper, and it's really sort of a fascinating view. He's got sort of a view of the benefits and the lack of benefits about regulation. So he's going to talk for 20 or 25 minutes. And then we've got Steve Bradbury, who I know all of you know from his years as the head of OLC, to talk about sort of cost-benefit relationships and how the government oversees regulation. And I'm going to do a little sort of experiment in regulation. You know, I don't have this sort of what John Roberts has, this sort of the red light goes on and he can say to the counsel, well, your time is up. And he's known as a very gracious guy because he'll say, well, you may finish your sentence, counsel, or unlike Chief Justice Rehnquist, who never allowed anybody you stopped right then. I've also moderated a lot of panels where I've tried self-regulation of the speakers on the time. And it's frequently the case that you've got four speakers up, and I realize the first person is in the 14th minute of a 5-minute opening talk. I think, well, maybe self-regulation is not always good. So we don't have strict regulation. We're not going to have total self-regulation. We're not going to rely on. So I want all of you, about 20 or 25 minutes into Professor Meltzer's talk, if he's gone past 25 minutes, I want some of you to start to raise your eyebrows here in the front row or say, and then if I hear one or two of those, I'll give you a which means your time is nearing an end. So let's see how this form of regulation works. Professor Meltzer?
Thank you. Thank you very much. I'm going to read my paper. I don't usually like to do that, but this is an area which is new to me. So I want to say exactly what I've written and not something else. At my grammar school in the 1930s, we learned that the United States was a government of laws and not of men. This meant, we were taught, that our founders protected the public from arbitrary authority. In the U.S., we followed the rule of law as closely as possible, equal protection of citizens under the law. We never discussed how close we came to realizing that goal and ideal in practice. Regulation is often a clear exception to a government of laws. As regulation has increased in the 20th and 21st centuries, more activities have become subject to the rule of regulation, filled with many special provisions that benefit some at the expense of others. With increased regulation comes circumvention, crony capitalism, and occupation and corruption. In the commercial area that I know best, banking and finance, corruption and circumvention are common and familiar. In Federalist 10, James Madison famously warned that factions threaten democratic government. Currently, we substitute interest groups for factions. Making specific regulatory policy is often the outcome of discussions and consultation between regulatory staff and lobbyists representing particular institutions. The public interest is lost in these negotiations. In its place, we find rules that favor particular firms and groups, penalize others, and rules that can be circumvented. Long ago, I knew this happened from reading the literature on regulatory capture. A few years ago, at first hand, I gained insight into the extent of regulatory circumvention. I gave a talk on Regulation at the Council on Foreign Relations in New York. The Council received substantial support from financial firms, so the audience had a large number of employees of such firms. I discussed regulatory circumvention and gave some examples. The first person to speak in the question period that followed proudly said, "I'm a lawyer. I work on Wall Street. Who do you think shows them how to circumvent costly regulation? We do." The pride with which this declaration was offered strongly suggested that circumvention was established common practice. First, I argue that regulatory trends harm society by reducing competition as well as by increasing crony capitalism. For those reasons alone, we should seek to strengthen the rule of law. Second, because many regulations are easily and often circumvented, there are better ways invoking the rule of law, and I'll give some example, that accomplish what regulation in the public interest should seek to accomplish. Where significant differences exist between private and social costs, regulation should work to close that gap. Below, I discuss ways to close the gap consistent with the rule of law. Let me state explicitly that this paper is not against regulation per se. It seeks to make regulation compatible with the rule of law. Third, regulatory policy rewards interest groups, factions, so it enhances the dangers that Madison warned against, and it weakens protection of property rights and market competition on which our future depends. Before developing that theme, I suggest the main pressures that drive regulatory policy away from the principles summarized in the rule of law. The main force is common to much economic legislation, the never-ending conflict between those who favor more redistribution of income and wealth and those who favor policies that encourage growth and increase per capita income. I worked on that problem many years ago, showed that in elections, voters choose generally between policies that redistribute income by increasing tax rates and spending and policies that encourage income growth by reducing tax rates to encourage investment. The same general principle applies to regulatory policy. Those who favor redistribution support regulation that favors specific groups and regulate specified behavior or actions. Thus, regulation of banks now includes provisions that favor minorities or low-income earners. Other regulation favors wind or solar energy, or at an earlier time, production of oil. The list is long and growing. In a democratic market economy, it is probably impossible to avoid a struggle over the distribution of income. It may be possible to protect regulation from being influenced by that struggle. That would be a major step toward strengthening the rule of law and increasing economic efficiency. My essay is silent on the social benefits and costs of redistribution. Governments have ample opportunities to use the tax and transfer system while maintaining a regulatory system based on the rule of law. The next session of my paper follows some work by a lawyer, professor of law named Tamanaha, who described what the rule of law is and what it does. And I'm going to skip over that in the interest of time because most of you are lawyers, so you probably know that better than I. A famous jurist emphasized three aspects of the rule of law. Quote, "No one can be punished or made to suffer except for a breach of law proved in an ordinary court. 2, no one is above the law and everyone is equal before the law, regardless of social, economic, or political status. 3, the rule of law includes the results of judicial decisions determining the rights of private persons." End of quote. That's a quote from Dicey in 1885. Friedrich Hayek emphasized the absence of arbitrary authority. Quote, "Under the rule of law, government is prevented from stultifying individual efforts by ad hoc action. Within the known rules of the game, the individual is free to pursue his personal ends and desires, certain that the powers of government will not be used deliberately to frustrate his efforts." End quote. You can think, as I talk, about how far we have strayed from those principles. Now, it is not my belief that we can achieve them without flaw. We are human. We have flaws. We can do better. We can't get perfection. One of the problems we have is that people finding fault often see that they need to move to something that they think is perfection. To sum up, there is general agreement that the rule of law applies uniformly to everyone, insofar as feasible or possible. The rule restricts arbitrary actions by government and reduces uncertainty. As such, it encourages investment in economic activity and enhances the security of property rights. The rule of law is a human institution, so enforcement is never perfect. Several of the problems that make enforcement difficult are subject to extensive literature, starting with Ann Kruger's paper on rent-seeking, public choice. There's a large literature. Recently, as large budget deficits and reduced opportunities to redistribute income through tax and spending policies, redistribution has taken a larger role in regulatory policy. The following section presents some examples where uniform treatment under the rule of law is sacrificed to benefit particular economic groups. The Dodd-Frank legislation in 2010 that revamped financial regulation includes a section authorizing a director of the Consumer Protection Bureau within the Federal Reserve responsible for implementing consumer protection legislation, including the rules that banks must follow when deciding credit allocation. Chris DeMuth, who ran OIRA at one time, describes the new act as having, quote, entrenched the very policies that had contributed most directly to the financial collapse, end quote. The new provisions have several unusual features. The director does not report to the board's governor. He or she is made independent and given authority to finance spending by the agency using the income up to a limit that the Federal Reserve receives from its portfolio. For many years, 90% of that income went to the Treasury. The new procedure allows funds that would go to the Treasury to be used for purposes decided by an unelected official subject to very little oversight. The reason for this legislation is to increase the share of bank lending allocated to, quote, disadvantaged groups. This is redistributive action intended to benefit some groups at the expense of others. They become advantaged. The newly disadvantaged will be small businesses and small startups that will get a smaller share of the credit supply. The rule of law is replaced by the rule of regulation. The Dodd-Frank legislation continues many other departures from the rule of law. Since the 1970s, regulators have declared large banks, quote, too big to fail, end quote. The claim is that a failure would disrupt financial markets to an unacceptable extent, so the regulators prevent the failure by lending or giving financial aid. As the practice became known, large banks recognized the advantage of becoming larger. Knowing they would not fail, lenders offered credit to these banks at lower interest rates. They could lend, in turn, to their customers at lower rates, a competitive advantage. A rising share of credit is done by the very largest banks. Unable to compete effectively, medium-sized banks sell themselves to the giant banks. The historical aim of financial policy in a crisis caused by failures has been protection of the payments system. I want to emphasize that, the payment system that facilitates trade. Protecting the payment system has long been judged appropriate and reduces divergence between private and social cost. This historic policy has shifted to the protection of giant banks. This is redistributive and contrary to the rule of law. Too big to fail is contrary to the rule of law. The rule of regulators replaces the rule of law. The proponents of Dodd-Frank recognized that too big to fail was costly and inefficient, but their legislation does not eliminate it. Instead, it empowers the Secretary of the Treasury to decide whether to invoke too big to fail after consultation with other financial regulators. That formalizes a process that has been in place for many years. The Treasury Secretary has made all past too big to fail decisions after consulting with the Federal Reserve, the Federal Deposit Insurance Corporation, and other regulators. Leaving this decision about failure until a failure is imminent biases the decision in favor of a bailout. Section 2 of Dodd-Frank permits discretionary authority to treat some creditors more favorably than others. Few, if any, officials would knowingly risk the spread of failure to other banks at home and abroad and to the economy if required to choose what to do in the midst of a crisis. I can say that I have been there, and I know there is no argument that you can make that is going to overcome the pressure that comes from 8 or 9 assistant secretaries who tell the secretary all the terrible things that will happen if he doesn't do the bailout. The wrong time to think about the bailout is when you're in the midst of a crisis. The only reliable way to eliminate too big to fail is to establish a rule in advance and enforce it when failures occur. The rule I have proposed applies the rule of law and shifts responsibility for banking decisions back to bankers, where it was before too big to fail started. The rule requires banks to increase their equity capital reserves to a minimum of 15% of their assets. To avoid circumvention, all assets are assessed. Risk weighting is not permitted. If a bank is unwilling to put a minimum equity reserve behind some assets, the bank should sell the asset. Banks not subject to too big to fail would hold less than 15% equity capital ratios. Why 15% minimum only for the largest banks? Smaller banks are subject to deposit insurance, for which all bankers pay. The system has worked well in several periods of financial stress. Increasingly, the large banks finance their assets with purchased liabilities, not just deposits, and they are considered too large for deposit insurance agencies everywhere. The choice of a 15% minimum for large banks is not entirely arbitrary. During the downswing phase of the Great Depression, 1929 to 1932, no large New York bank failed. They had equity reserves of 15 to 20%. Knowing that they were responsible for losses, they were more prudent lenders. Under proposed Brown-Ritter legislation, which I helped to write, a study will be done to learn whether a 15% minimum remains appropriate. Legislation to adopt a rule of this kind is contained in the Brown-Ritter bill offered in the Senate. Passage would restore the rule of law to this problem and eliminate too big to fail. The proposed law protects consumers and taxpayers from the cost of financial failure and promotes safety and soundness. The Federal Reserve System serves as the principal regulator of financial firms and markets. The 13 Federal Reserve Act prohibited direct financing of the Treasury. This prohibition was later relaxed slightly by providing by limited amounts of direct finance. Circumvention is far more important. Barred by law from purchasing Treasury securities directly, the Federal Open Market Committee buys the securities in the market on the same day. In the past few years, the Federal Reserve purchased more than 75% of the Treasury's issue. Is it a part of the American system that an agency of government without very much supervision of any kind can triple the size of its balance sheet? Not the America that I know and love. Following the bank and financial crisis in 2008, the Federal Reserve tripled the size of its balance sheet, adding more than $2 trillion. This raises two critical questions. Can the Federal Reserve prevent an eventual inflation once banks start to use the increased reserves that are now almost entirely idle? Second, should any agency have unregulated and largely unsupervised authority to increase its resources by more than 200% without congressional approval? After the housing and financial trauma in 2008, the Federal Reserve departed from its long-standing neutral credit policy by purchasing more than $1 trillion of mortgage securities. As Goodfriend emphasized in a paper, this is credit allocation that favors particular firms and industries. Other research sets out conditions for a government agency to remain independent of pressure from political and private interest groups. There must be enforceable rules that are sufficiently transparent to be monitored by outsiders. The paper then shows many examples of the failure of federal regulatory policy to meet that standard. These departures violate the rule of law by giving advantage to some, disadvantages to others. A recent example of the approval process is the approval process for bank mergers. Local groups use the process to increase lending for the particular groups regarded as disadvantaged. Instead of closing or reducing this departure from the rule of law, the Dodd-Frank legislation authorized more discrimination in allocating credit. Perhaps the most extreme regulation to redistribute credit are the decisions by federal regulators before the financial crisis to permit no down payment loans, subprime loans, and so-called liar loans. The intention was to expand home ownership to poorer voters. The result was massive failures and foreclosure. This policy was endorsed by presidents of both political parties. The Federal Reserve Bank of New York has generally represented the views and interests of large New York banks. After 2008, the support increased markedly. An example is the decision to purchase $30 billion of credit default swaps from American International Group, which American International Group had sold to domestic and foreign lenders. The New York Fed paid the full face value using money that would otherwise be paid to the U.S. Treasury, that is, taxpayer money. The market value of the swaps was substantially lower. This action transferred public money to private lenders. Settlement of the General Motors and Chrysler bankruptcies transferred much of the ownership to the company's labor unions in one case and to a foreign corporation in the other. Bondholders who were primarily creditors were prevented from exercising their rights. Prevailing law was set aside. A vast literature on regulatory capture discusses the common occurrence of agents or principals of the regulated industry taking responsibility for regulation of their firms and industry. The Securities and Exchange Commission is a prominent example. Industry leaders become SEC regulators, and SEC regulators become industry leaders. Some move back to the SEC after years in the financial industry. Former SEC employees represent clients in SEC cases. For a decade before the Madoff Ponzi scheme failed, a financial executive, Harry Markopoulos, attempted to explain to SEC officials 6 times that Madoff could not be doing what he claimed to do. He got no response, at least in part because the SEC regarded Madoff as a prominent financial executive. During the 1980s, regulators permitted savings and loans with reduced or impaired capital to use so-called regulatory accounting instead of generally accepted accounting standards. Eventually, most of the firms with impaired capital failed, costing taxpayers an estimated $150 billion. Regulatory accounting may have misled some depositors or investors. It is special treatment and thus a violation of the rule of law. My examples are drawn from the financial industry because of my acquaintance with that industry and its practices. Special treatment of those with preferences, violations of the rule of law, however, are not limited to any set of industry regulators. The Federal Aviation Administration allowed airlines to avoid safety inspections despite the concerns of its own inspectors. The agency has been cited as an example of regulatory capture. Peter Shook pointed out that the Federal Communication Commission was an industry captive that, quote, inhibits new entry, stifles innovation, and diminishes consumer choice, end quote. An FCC commissioner voted to approve the merger of Comcast and NBC Universal. 4 months later, she went to work for Comcast. The Affordable Care Act authorizes hundreds of new regulations of doctors, hospital, insurance companies, and the public. Among other provisions, the legislation expands benefits, eliminates exclusion of people with pre-existing condition, restricts the ability of insurers to refuse policies, imposes new requirements on communication, mandates that records be kept on computer files, and taxes health insurance and benefits. The Act has some explicit rules, but most of its provisions delegate rulemaking power to the agencies, offering many new opportunities for circumvention and corruption. One particular provision requires individuals to pay a much smaller fine if they do not buy insurance than then is the cost of that insurance. The intention is to reduce the free rider problem by fining healthy young people for not paying part of the cost of insuring older people. But the differences between the fine and the cost of insurance is likely to fail to produce the desired result. Congressman Henseling, chairman of the House Financial Services Committee, described the allocation of credit under the new law rules this way, quote, "How is it fair that one's unelected, unaccountable bureaucrat in Washington has the power to decide what kind of mortgage, car loan, or credit card they can or cannot have?" Would you hand me my water, please? Thank you. Can there be any doubt that the rules will not be applications of the rule of law? By using examples drawn mainly from finance, I may have suggested that the problem is limited to financial regulation. The truth is very different. Regulation to redistribute, pardon me, regulation to redistribute in ways that aid interest groups and bypass the rule of law are common in Federal Communications Commission rules for the allocation of spectrum, the Environmental Protection Agency rules to regulate pollution, National Labor Relations Board rules to promote labor unions at the expense of employers, and in other agencies, including the possibility, indeed the problem pervades modern government in many of its operations. Regulation no longer aims to remove externalities or market failure. Increasingly, regulation redistributes for political or paternalistic concerns. All price and wage controls in non-monopolized markets are examples. The rule of law is absent. Violations of the rule of law are common and growing. My list can be extended considerably. The point should be apparent from the examples. Regulation is captured and circumvented. It is a major source of crony capitalism. Large firms pay the cost, so they're able to encourage regulation and restricts competition. These cases of special treatment violate the rule of law. The problem is not new, and the outcomes have been studied extensively in India and Latin America. Using regulation to redistribute income in these areas increases monopoly positions, encourages corruption, and reduces economic growth. The public seems to recognize that more regulation is not in their interest. In the most recent 2012 Gallup poll, the question was, quote, "In general, do you think there is too much, too little, or about the right amount of government regulation of business and industry?" End quote. The responses showed 40% choosing too much, 20% choosing too little, and 24% choosing the right amount. The poll did not ask about the type of regulation. I believe the methods of regulation are a major problem. So I'm going to turn to that in my closing minutes. Every economics student learns about the differences between private and social cost. Regulation is a principal means of reducing the gap between the two. As the earlier examples show, regulation often fails to meet that standard. The principal reason for the failure is that much regulation is hortatory and prescriptive, representing some desires on the part of members of Congress, special interests, or administration officials. Economic analysis of externalities, like air and water pollution, establishes that the best solution is to tax the polluter enough to equate private and social costs. All economists they don't support anything generally, but they all support this conclusion. But it is politically unappealing because it raises costs, taxes. Politicians prefer to substitute exhortation, prohibition, and regulators' decisions and control for market decisions. They can increase campaign funds by favoring some at the expense of their competitors. The use of markets has a benefit that political decisions lack. Markets are impersonal. They change the incentives faced by the regulated firm. Properly imposed, the owners or managers of regulated firms can gain an incentive to choose the socially appropriate outcome instead of circumventing the regulation. Here's an example from financial regulation. The social cost of failure by large banks creates pressure for preventing failure at taxpayer expense. The social cost of failure is large. Failures disrupt the payment system and greatly increase uncertainty. In a failure, the cost of bank shareholders is the value of the bank's equity capital, a cost that has fallen dramatically with deposit insurance and too big to fail. In the 1920s, before these policies were in place, as I said before, large banks in New York held 15 to 20% equity capital. During the worst banking period ever, 1929 to 1932, none of the largest New York banks failed. As a matter of fact, Herbert Hoover went to New York and met with the bankers and asked them to put up $50 million each to establish something called the National Credit Commission, which later became a public corporation, the Reconstruction Finance Corporation. The bankers agreed. That meant that they had $50 million that they were able to do, a lot of money in 1932. High equity capital ratios encouraged prudential portfolio policy. To close the gap between private and social cost, all of the banks now considered too big to fail should be required to hold a minimum equity capital equal to 15% of their total assets. All assets count equally. Risk weighting would introduce circumvention. If a bank believes that the cost of reserves against some asset types is too high, they should sell the assets. Equity capital requirements impose market discipline. Large stockholders would monitor the bank's portfolio. If losses became large enough to impair the equity capital requirement, the share price would fall, inducing a response by management before bankruptcy or insolvency occurs. That is why they must hold much more equity capital. And I emphasize equity capital, because when they held bonds as part of their capital, they insured against them, so they had no real danger when they failed. They got the effective capital down, in some cases, to 1% of their assets. Banks smaller than the very largest would have lower equity capital requirements. Regulation has devolved into political action that seeks objectives other than achieving the public interest. Regulation that closes the often wide gap between private and social cost requires the design of incentives that encourage private action that achieves social ends. Restoring that goal as the principal goal of regulation and designing incentives that achieve the goal should be the main objective of regulatory policy. In other words, when we see a difference between private and social cost, we want to find methods which will make the people who are to be regulated bear the cost, so that they have an incentive to close the cost, to behave in a socially responsible way. In The Road to Serfdom, Friedrich Hayek wrote, "The rule of law thus implies limits to the scope of legislation. It restricts it to the kind of general rules known as formal law and exclude legislation that either directly aimed at particular people or at enabling anybody to use the coercive power of the state for the purpose of such discrimination," end quote. Regulation has strayed far from the principles introduced in the rule of law. New regulation takes us farther away from the principles we claim to uphold. That path has led in many countries to corruption, crony capitalism, and special privileges. There is an urgent need to begin the long trek back to principle. We are often asked to abandon the rule of law in the name of fairness or social justice. Have we not learned that these terms remain undefined, a cry for redistribution that can never be fully satisfied? As recent scandals shows, the efforts to achieve fairness bring corruption. Corruption is well established. The United States scored 73 on Transparency International Corruption Index. That put us equal to Chile and Uruguay, but 17 percentage points below Sweden. It is not surprising that regulation has increased under congressional and court procedure. Most congressmen think first and most not about economic efficiency, but about who gains and who loses from legislation and regulation. Economic efficiency and the improved working of our capitalist system would limit regulation to providing public goods, mainly by closing as much as possible gaps between private and social cost. We must reform regulation and increase its effectiveness by changing the incentives of the regulated. Good, proper regulation makes the regulated want to achieve more of the social benefits. Prohibitions and exhortations end with circumvention, corruption, and crony regulation. We have ample opportunity to redistribute income through the tax and spending system. We should leave it out of the regulatory system. Thank you.
Thanks, David. Thank you. Yes, go ahead. Thanks. And let me just say, it's an honor to be on the panel with Professor Meltzer and also with David. And I appreciate the sort of refreshing message of his talk and kind of getting back to fundamental principles, first principles, and the basics, and the liberal quotation of Friedrich Hayek. Let me say, though, I do have a different perspective. And sort of in light of those first principles, I think I have a different conception of the rule of law as well. James Madison may have dreamed that he and the other founding fathers could create a government that would be free of the influence of factions, what we now call special interest groups. But that was never an achievable aspiration. And I think the real genius of the constitutional structure that we've inherited from them is the checks and balances of our system of separated powers and how that allows special interests to lobby and participate for the objectives and policies that each particular group is most interested in, and yet the whole operates in a way that's balanced, and one source of power will check another. I don't think special interests are a bad thing. I think they're natural. I think it's human society in all its variety. I define a special interest group as a group whose property is on the line with respect to a particular law, or whose business interests or other financial interests are at stake. They have a real stake in the issue, or they actively care very much about the issue, so they happen to devote a good portion of their life's work to achieving a particular policy goal, learning about it, etc. I think special interest groups and the lobbying that they do in the legislative process enrich the process. I think most honest members of Congress would tell you that they learn a lot from the representatives of special interest groups who know the most about a particular issue that they're debating. And it does mean that in the legislative process in Congress, there will be winners and losers. Big railroads will be treated differently from little railroads. And I think that that is inevitable in a large, very variegated and rich society. But under the genius of the founder's scheme, we have two houses of Congress, not just one, and they both have to agree to the letter on the very same piece of legislation for something to become law. And one of those two houses, every single member of the House stands for re-election every 2 years. So if they favor the big railroad over all the little railroads, and that makes a lot of people unhappy, they'll be voted out of office in 2 years, or at least there's that opportunity. And of course, 1/3 of the Senate now every two years. And then the president, who's elected by everybody in the country, has to agree for it to become law, or there needs to be a supermajority in Congress. And then the genius of the executive branch, which I think is a key innovation of our Constitution, is the concentration of political accountability in a single individual who sits atop the executive branch and is responsible for the execution of those legislative policies and making the rules that carry out those policies. And to the extent Congress, within its power, and there are real issues as to whether Congress has gone too far in the delegation of legislative power, particularly under legislation like Dodd-Frank or Obamacare. But to the extent Congress has ceded power to the executive branch to design rules to implement the details of legislation and fill in the gaps in policymaking, et cetera, the political accountability, very effective political accountability that concentrates in the person of the president is the singular check on out-of-control power in those administrative agencies. And I think that's what I want to focus on today, is the exercise of that power that resides in the president to oversee the executive branch and to supervise the conduct of the administrative state. And there is where I think we really have gone astray in terms of the rule of law, but also the moving away from the first principles that the founders designed. I think the real problem is not that one faction captures an agency and one faction wins out over another faction in the administrative process. In fact, I think the problem is a problem that Friedrich Hayek would have identified if, for example, in his book, The Fatal Conceit, he identified the fatal conceit of socialism was the idea that some elite of experts could decide how to organize society and the economy better than private markets and capitalism could. That's what he identified as the fatal conceit that really meant socialism was doomed. And I think that's part of the problem with the administrative state, because the notion we've come to have since the late 19th century, then after the New Deal in spades, is the notion that in complicated areas like bank regulation or environmental regulation, there's a notion that there's an expert scientific answer, a sort of Rawlsian response or policy that is the ideal policy that will try to avoid some people getting treated better than others. And so it's objectively reasonable and it's scientific and the experts will work it out. And so the notion is Congress has a tendency in these statutes to cede enormous policymaking power to what it views as the expert administrative agencies. And then it requires that when they come up with rules, they do so through this open notice and comment public rulemaking. Actually, in fact, I would say for the most part, the attempt is to insulate the agencies from lobbying and from what is feared to be the capture by powerful interests in particular industries. So the notion develops that these agencies are quote unquote independent. And of course what that means in design is independent of the president, independent of the president's ability to supervise the development of policy in these agencies. And so what comes to be is we have massive staffs of bureaucrats in the agencies who happen to be mostly lawyers or economists, mostly lawyers, unfortunately. And they sit back. In many cases, they don't have much experience in the industry. They don't have very much practical experience. They think they understand how it works. They think they understand how it should work. They have a sort of aspirational vision of how those markets or industries should ideally work and how everybody should conduct their practices in the industry, and they try to come up with Platonic ideals of rules through the notice and comment process, exercising enormous power over vast swaths of the economy. And the notion is that they're independent of the president's political accountability because the heads of those agencies are restricted in the extent to which the president can remove them from office. And the typical formulation for these restrictions is that the head of the independent agency or the multiple heads of a commission can only be removed by the president for inefficiency, neglect of duty, or malfeasance in office. That's the formulation you see, for example, for the director of the Consumer Financial Protection Bureau, and it's typical of these for-cause removal restrictions that apply across these independent agencies. The notion is, the actual notion is we're going to try to insulate the rulemaking in these expert agencies from anything like the vision that Professor Meltzer laid out, which I would call political accountability. And so the president is unable to direct the policy, the exercise of policy in the agencies and say, here's the rule you should follow, or there's the rule you should follow. If he does that, he could be taken to, first of all, the agencies will thumb their nose at the president. If he tries to remove the head of the agency for failing to follow the president's preferred policy, the head of the agency will go to court and will sue for reinstatement and back pay and will win in the DC Circuit because the courts, stretching back to the Supreme Court's decision in Humphrey's Executor, have blessed this system as consistent with the Constitution. So we have a system where these agencies on their own with actually little political accountability, they do have budget accountability to committees in Congress, but it's highly attenuated compared to the sort of accountability that, for example, the Secretary of the Treasury would have, who is answerable directly to the president and can be removed at the president's pleasure. So we have statutes in place that insulate these agencies and the conduct of policy from the president. And the question I want to focus on specifically is how far can the president go to try to reassert control over the activities of these agencies? And I'm not going to suggest, given the court decisions that are out there, that the president can go as far as to dictate policy. But I want to focus on one of the words in those typical statutes that provide for insulation from presidential removal, and that's the word inefficiency. The heads of these independent agencies can be removed by the president for inefficiency. And I think that word can do a lot of work. If you think about cost-benefit analysis in administrative rulemaking, it is the definition of efficiency. It's the agency taking account of the practical effects, economic effects, to the extent it could be monetized, economic effects of the rules that it adopts, and attempts to quantify the benefits of the rules it's adopting and to quantify the costs and to balance those. For some years since the Nixon administration, the president has directed that the Office of Management and Budget conduct a regulatory review of all major rulemakings in executive agencies, that is to say, agencies whose heads do serve at the pleasure of the president. And OMB, over the years, has developed an effective system for reviewing every rulemaking and entering into a dialogue with those agencies, asking them questions. There's an iterative process. They go back and forth on the cost-benefit analysis supporting every rule. President Reagan dictated in his executive order that no major rules should be passed unless the benefits outweigh the costs. Now, that's changed a little bit. In 1992, President Clinton changed that wording slightly, but in a very meaningful way, to say that the benefits justify the costs. Well, of course, what's justified can be in the eye of the beholder, but nevertheless, the process is still in place, and it is applied consistently. And what it does is it enables the president, through the director of OMB, to ensure that agencies across the executive branch, those who do answer to the president, conduct consistent, thorough, detailed cost-benefit analysis to support every major rule, and they ensure that it's consistent across the government, and that the rulemaking in one agency takes into account related rulemaking of another agency, so you don't get overlapping costs and benefits in an inefficient way. And that has worked effectively. And actually, under this president, he's been pretty good about it. He's larded it up with some additional objectives, which I might take issue with, but he had a pretty good guy, Cass Sunstein, who's actually a veteran of the Office of Legal Counsel, who did a pretty good job in overseeing this cost-benefit analysis and actually got the president to sign, President Obama in 2011 signed an executive order that said all independent agencies too should submit their rules to the OMB for similar cost-benefit analysis. Of course, they don't do that because should means I think you should. I mean, it's something that's optional. There's a new guy coming in taking Cass Sunstein's place, Howard Shalansky, who's also very talented, very smart, young lawyer. To me, he's young, lawyer and economist who has just come over from heading up the Competition Bureau and the Economics Bureau at the Federal Trade Commission. He's a good guy. He's been nominated by President Obama to head up OIRA. And my hope is that under the advice of Howard Shalansky, that the president might actually consider going further than his executive order in 2011 and actually mandating that all quote-unquote independent regulatory agencies submit their major rules to OMB for its cost-benefit analysis review as well. There's been some legislative proposals in Congress to indicate that the president may do this. I don't like some of those proposals because they kind of they would codify in statute some of the standards that the Clinton administration executive order adopted rather than the Reagan order. So I don't really like that part of it. And I don't think it's necessary for Congress to say the president may do this. I think the president has authority to do it. And I think it's consistent with those for-cause removal statutes because the president can say, if you're not going to agree to submit your significant rules to OMB review to ensure that your cost-benefit analysis is consistent with the cost-benefit analysis of other agencies and is done in a thorough and meaningful, economically meaningful way, and if you're not going to submit your rules to OMB to ensure that there's not overlapping and inefficient conflicts or inconsistencies with the rules of other agencies in other parts of the executive branch, then I'm going to say you're acting inefficiently. And I'm going to require you to agree to submit your rules to OMB review, cost-benefit review. Again, the OMB review, as a formal matter, doesn't second-guess policy decisions of agencies, but it does second-guess the accuracy, consistency, and thoroughness of its cost-benefit review, and that's what I'm focusing on here. And I think the president could lawfully, consistent with these statutes, say to these agency heads, if you refuse to submit your rules, I will ask for your resignation on grounds that you're not operating your agency efficiently. And I think I'd like to take that case if I were inside the government to defend that position. I think it's very defensible. And I think it would ultimately prevail in the Supreme Court. What does inefficiency mean? The president gets to put some content into that word. I think if the president were to do this, what I'm suggesting is it would not require any change in law, could go a long way, not as far as we would like, but could go a long way toward getting control over the rationality of the rulemaking process at the SEC, at the FCC, at other agencies, the operation of the Fed, et cetera, and would get us at least incrementally a little bit closer back toward the vision of the founding fathers. I think that a lot of the problems that Professor Meltzer identifies are problems with the legislation. You know, unfortunately, 2 houses of Congress passed it, and a president signed it into law. I think we could, there's a lot of us who might disagree vehemently with some of the policy decisions that Congress made. What it certainly has produced is an avalanche of rulemaking now to try to fill in the gaps in that legislation and make some extremely important calls. And I'm actually worried that those agencies are filling in those gaps in a way through a process that is in fact too insulated from the special interest groups that are most impacted by these rules and that have the most to offer in terms of how those rules could be most rationally formulated. But I think that's a bigger debate than the simple change simple, but it would be a big change. I'm talking about in terms of how the president supervises the executive branch. Okay? Thanks.
Thanks, David. Well, there was a fascinating two different views of regulation, wasn't it? One is it's about corruption and self-dealing, and Stephen's much more optimistic view that this is about politics and the political clash of interests and political accountability. So I'm hoping some of you have some questions, and we've got about 25 minutes, I believe. Anybody have any questions I can ask a few, but I'd rather have some of you go first. Questions, anyone? Yes, sure, Professor Meltzer. Let him respond first.
Let me say, I don't believe that Madison and the Federalist had his eyes shut and believed that only good people would do good things. Federalist papers are very much against that tradition. It was to convince people that they had a government that needed surveillance. That was what the eventual Bill of Rights was hopefully going to do. So I wrote a book called Why Capitalism last year. The running theme in that book is a statement of principle from Immanuel Kant, the great German philosopher, that says that from timbers as crooked as those from which man is made, you do not get straight boards. So I'm not a perfectionist, and I don't believe I have a utopian solution. I think the real difference between me and my discussant, and I thank him for his comments, I think the real difference is he believes much more than I do, in fact, considerably, greatly more than I do, in the rule of men. Good men will make good laws, and I believe in the rule of law. That is, I don't trust good men because good men are corruptible. And we certainly I don't need to give you many examples. We can read them in the newspaper almost ad nauseum these days. And, we had them in the Nixon administration. We've had them in administrations between Nixon and the present, but not to the same degree. What's at fault here? What's wrong with the idea of good people? Bankers contribute large sums to campaigns. Other industries similarly. They buy access to regulators and use it to improve their relative position. I don't blame the bankers for doing that. I expect people to act in their own interest. It's the rules that we have to change. We have to make it so that they want what is socially desirable. Will we achieve that perfectly? No, we will not. Can we get closer than we are? Oh yes, we've drifted a long way from that. So although David seemed critical at some points in his remarks and favored the rule of men over the rule of law, he talked about capture, and I would add crony capitalism and corruption. He has to explain to me how we're going to get rid of capture, crony capitalism, and corruption if we just put our faith in individuals to do good things. That doesn't work. People follow their incentives. You change their incentives, you change their behavior. The rule of law is a way, my emphasis on the rule of law is a way to change their incentives. There may be other ways. This is the way I have found. I'm beginning a project which I hope will come to fruition with the law school at Stanford and the Hoover Institution to look at these things in detail, to document how much really we deviate from the public interest in the directions in which we go, and to try to restore the rule of law. Because, as I said, I believe that the foundation of the American system is the rule of law. It protects private property. It protects individual initiative. It gives incentives to do the things that made America what it is. We want to get back there. Thank you.
I guess the rule of law calls for a response from your side. Did you want to say anything? response to that? Okay. Yes.
Based based on the history of the lack of success of so many regulations, whether it's EPA cleaning up the air and the water, which if you listen to environmental groups, they'll tell you it's worse now than it was before there was an EPA, and we only need more regulation, to the IRS's demonstrated incompetence, to the FBI's inability to prevent 9/11 in spite of the fact the evidence was, in many cases, sitting right there in front of them, and then nobody was held accountable for the failures afterwards. Why is there any basis, any rational, realistic basis, for believing that regulation will ever work? Because going back to the ICC, they found letters from Edward Harriman saying, look, the best thing that could happen to the railroads is to create an ICC because we can capture control of it and then we'll be insulated from a lot of state regulation. And that's 120 years ago. So what is the basis for anybody thinking that this whole mess can ever be straightened out? And if so, how would you straighten it out?
Stephen, I think Stephen's a better one for that one.
Well, I agree. I mean, I'm not defending the administrative state or regulation. I think my point I was trying to make is I don't believe there is, I don't believe in the legitimacy of this notion that we can have agencies of experts making perfect regulatory judgments and insulating them from political accountability. And I think that's the model that some of these big pieces of legislation that create these agencies and endow them with extraordinary power is based on. And I think that that's fundamentally illegitimate under the first principles reflected in our constitutional structure. So I agree with you, and if in terms of the policy of what the regulations should be, I think that we should favor something wherever possible that's closer to, for example, the bankruptcy code, where complicated issues that Congress doesn't have the time or ability to work out are worked out among the parties with the most at stake, with a judge ultimately reviewing the decision and the compromise that is reached. There's a negotiation around a table, effectively, in every bankruptcy. That's true for certain forms of environmental regulation, like CERCLA, which, I mean, you can question the wisdom or purpose of the whole statute, but one of the things it does is forces the parties with property interests at stake to get around a table and negotiate who's going to be responsible for what portion of the costs. And I think that's a kind of model that gets away from the notion that a bunch of lawyers, like we see in the SEC, for example, can sit back and decide the Platonic perfect set of rules for the markets to operate under.
How would you apply what you just said to EPA setting particular emission rules for power plants when the only real interested party are the power plants and the general public, which wants clean air but wants cheap electricity at the same time, effectively can't participate?
Well, that's the kind of common costs versus private costs, common benefits versus private benefits that I think Professor Meltzer was referring to as a legitimate focus of regulation. I think the way you'd want to try to do it is either have Congress make as many of the most significant decisions through the political process, through legislation as you can, and then have as much emphasis on a market-based solution to carry out the rest of the program. But I'm not saying there should be no regulation, there should be no agencies. I mean, that may be a good example where it's appropriate. But the EPA is subject to direct control and supervision by the president. There we have a sort of a different myth that it's all just scientific, and so the president tends to take a hands-off approach, or the statute itself says the director must make the decision based on science input A, B, C, and the president can't say, no, you got to take into account D. And maybe that's rule of law. I mean, that's a statute that says that. But that, it may be an area where it's appropriate. And I just think we need to emphasize more muscular presidential supervision.
Since I'm a Supreme Court reporter, let me interject it. I thought if you're interested in this subject, I highly recommend the decision they handed down about 2 weeks ago in the City of Arlington case. Some of you are familiar with it. I thought it was the most fascinating dispute between really the sort of leading conservatives on the court, with Justice Scalia on one side and the Chief Justice on the other side. And both of them, I thought, dealing with a really fundamental question, which is, should the court's policy be, as what Justice Scalia said, what I think of as a sort of 1980s Reagan-era deference approach growing out of the Chevron case, which is, we elect presidents, they're in charge of the executive agencies. If the executive agency passes a regulation that's an interpretation of that law, we, the courts, ought to stand back and defer to that. There were 6 votes for that position. That was Scalia and Justice Thomas and the 4 liberal members of the court. And then the Chief Justice wrote a really powerful dissent. It's one of the strongest essays I've seen him write, talking about the headless fourth branch of government and the notion that the courts need to be much more active and skeptical of regulations, but because in truth, the executive doesn't police a lot of these regulations, and a lot of them come from independent agencies where the executive doesn't have any control. So for whatever it's worth, if it's a group of lawyers, I highly recommend that. It'd be very interesting down the road whether Justice Scalia sticks with that view when we get a whole series of Obama administration regulations on the Health Care Act. Is Justice Scalia going to want to defer to all those regulations and say, oh, they're not for us to second guess them, it's up to Obama's agencies? Or is he going to be a little skeptical that the bureaucrats are going beyond the law to sort of make new law? But anyway, I thought it was quite an interesting exchange within the court as to what the court's role should be on second-guessing regulations. If we are largely... Another question?
I was going to just ask, I was interested in what Professor Meltzer was saying about aligning incentives. You're saying essentially from a policy point of view, when you making sure that you're taking account of what incentives you're creating really should be kind of almost the #1 role in making these regulations. Is that correct?
Yes. Let me step back from what you said. I mean, when you say, turn it over to the administration or Congress to make these rules, let's remember how we elect the government. I mean, a great part of the election, almost always an important element in any campaign is, are you in favor of more redistribution or are you in favor of more growth? That's true not just in this country, it's true in most countries. Whether we're going to redistribute now or whether we're going to grow, and as a result of growth, we're going to do more redistribution out of the proceeds of the growth. That's the central issue, has been the central issue in American politics and many other countries. And so the people we elect are people who are concerned with those issues, redistribution versus growth. You get a Reagan or even a Bush, and you're more inclined to go in the growth direction to the extent that you can get support. If you elect an Obama, you get more redistribution. Now, what you're asking is that they appoint people who will carry out something called the law, rather than interpret it to do the things which benefit them or their friends or the people who pay their campaigns and so on. I think that's a much harder task. I don't believe that my program is easy or is likely to be adopted soon. But it's worth fighting for because it's the right, in my opinion, the right way to go. But I don't think the other program is the right way to go because of the reasons I just gave. The people who are elected have other interests than the public interest foremost in their minds. I mean, I've worked with congressmen, I've worked in administrations, I've seen this happen. I can tell you, efficiency, public interest is not the uppermost thing to most congressmen. They're there interested in who gains and who loses. What does this do for my constituents? We have to expect them to do that. That's the incentives that they have. We're not going to solve this problem by telling them do good or do better. We're only going to solve the problem by changing incentives.
Dean?
Thank you, and so ends the first annual Executive Branch Review Conference of the Federalist Society. I want to thank our final panelists, our moderator, David Savage, Mr. Allan Meltzer, and Mr. Stephen Bradbury as well. Obviously, there was a lot left unsaid. We tried to cover a lot of territory today, but there's been a lot left unsaid. The discussion and the debate will continue as we, the practice groups of the Federalist Society, do year-round programming, standalone programs, and of course, our teleforum conference calls. You can look us up on our website, but also on the blog that we launched that I mentioned this morning. I invite you all to continue and join in the conversation on our blog and on our continued programming. We'll be in touch throughout the year, but until we see you again, we're adjourned. Thank you.